Hi, I'm some guy studying law, and today I will be analyzing with you the case of Bethel v. Fraser 478 U.S. 675, which occurred in 1986. Bethel v. Fraser dealt with a student giving an obscenely worded speech to a student body. He was then suspended for 3 days and tried to reason that his First Amendment rights were violated. However, it was found that his rights had not been violated, likely due to the obscene nature of his speech. The Supreme Court held that the First Amendment does not prevent the school from disciplining students for obscene language, as distinguished by Tinker v. Des Moines Independent Community School District 393 U.S. 503, which is an example of legal research, which is one of the most important things that a lawyer can do. Another cited case was FCC v. Pacifica Foundation 438 U.S. 726. Which was used to explain that the First Amendment doesn't protect him due to him broadcasting the speech to other students, along with Ginsburg v. New York 390 U.S. 629, which was used to explain that due to the obscene nature of the speech, it is not protected by the First Amendment the same as political opinions would be. In the end, C.J. Berger delivered the verdict that the rights of the student were not violated. Before we continue, just so you know, the rest of this video is a commentary of what I think of the case. If you don't want to hear what I have to say about it, then close out of the video. I think that the verdict was fair, but only because of the explicit nature of the speech. Had this speech not been filled with such loaded language, and instead he spoke about political opinions or something of that nature, then I think that the student should have been relieved of disciplinary action. In the end, however, the student did end up speaking of sexual and explicit topics, which means that I think the ruling was entirely justified. This case is an incredible representation of how legal research helps to affect new cases because of the amount of previous cases that were cited during this one. I think that the case is pretty interesting because it can go both ways due to what people think the First Amendment truly means and how it is treated in a setting such as a school or a workplace. I want to know what you guys think. Do you think the ruling was justified, or should he have been exempted from the disciplinary action, or maybe even another disciplinary action tacked on? Let me know in the comments below. That's it for me. I'm some guy studying law, and I hope you all have a great rest of your day.